Good evening, everyone, and welcome to Genius Lakshya and a customized program specially designed for the students who are preparing for government competitive exam. Today is Friday, and as you all know, that every Friday we come up with an expert, and our today's expert is Mr. Rupaksh Sharma. As you all know that we have heard the term Vasudev Kutumbakam so many times. It is said that Vasudev Kutumbakam is the most famous phrase of Sanskrit literature. This phrase demonstrates of all inclusive attitudes of our culture, diversity and our world. Unity in diversity is the basic concept that we learn from standard 1 till we study and through our whole life. For thousands of years humans have been evolving. Earlier we were one, there were no boundaries, there were no any dividation, but right now we are divided into multiple countries. There are 195 countries in the world and 7 continents. So when the whole world is divided, there must be someone or some law abiding to it. That law is called international law. When we all, not exactly international law in term, not the exact definition of international law is dividation of boundaries, but yes, the rules, regulations, the protection rights that are given to all the humans, all the citizens, which is abandoned by a law, is the topic of today, which is international law. Firstly, I will give you a brief introduction of Mr. Rupaksh Sharma. Sir, we are glad that you are here with Genius Group of Institutions. Welcome, and we are expecting a great session by you. Welcome, sir. So, Mr. Rupaksh Sharma is Faculty of Law at Icfai University, Dehradun. Sir, can you please tell us something about Icfai?
Yes, ma'am, sure. Icfai University, Dehradun is the university actually constituted in 2003, and it has 11 s- university at the different states. And we at IUD, that is Icfai University, Dehradun, we have four schools basically, that is management, education, tech school, and law school. So I am here in the law school working as faculty of law.
Okay, so Rupaksh sir is right now working as faculty of law, and he's also teaching laws related to RTI, laws of torts, international human right laws, and laws of contract. Sorry. So he has been assistant professor at School of Law at Dr. K. N. Modi University at Rajasthan, right, sir? Okay. Uh, if we talk about his professional achievements, okay, there are so many, but we cannot waste our whole, or we cannot utilize our whole session on that. But we have a very qualified person as a expert today. I'll I'll mention some of his professional achievements. He is certified as a lawyer from Bar Council of India right now, and he is internal member of Human Rights Cell at ICFI Law School. Sir, we are really glad that today you are here, and we are expecting a really interactive and really interesting topic on international law today. Sir, over to you. You can start the session.
Thank you, ma'am. Thanks for calling me. It is a great, it's a pleasure for me to connect with you all, and not wasting much time, I will just come to the lecture. And before starting the PPTs, I would like to share with you the basic, as ma'am told that it is today is at present we have. It is not only about between the nations. It is not about one nation, but about all the nations now. So the rules, which the law rules, which are between the nations, which were among the nations, are considered as international law. As this is the general definition, as a layman, we are aware about it. Um, and in the different meaning, if you want to understand what is international law. It is something which is beyond the boundaries of the nation. As uh, when we talk about the laws and regulation within the boundaries of one country, it falls under the municipal laws or national law. Whereas if you talk about the relations between the states, between the different states, between the state of India and state of US, for example, that kind of relation falls under the international law. Now there are many type of relation also. Like some relations include the private relations, which means that which is affecting the persons privately. For example, if one person get married with another person who is citizen of the US, in that case, what law going to be applicable? That is a matter of a private concern. But as both party belongs to different countries, it will be governed under the first kind of international law, that is private international law. As the name suggests, private international law, the this law only include the private laws, private matters. As I given you the example of marriage, there are other example. For example, the jurisdiction of the court, adoption, succession, and the different even the corporations, those who are belongs to different country but come in India, and they have an office here, that how it's going to be deal, it will deal under the private international law. That is the first part of it. Whereas where the matter is between the amongst the nation, and it is related to the public, for example the rights of the citizen, for example the human rights of the citizen, and as well as the political relation, economic relation, social relation, but amongst these state falls under the public international law. So today we will talk about the international law, and these two kinds of laws are the basic part of it. Still, international law considered to be one of the important law in as a student of law you must, or as a student of if you're preparing for the competition exam, you must know about this international law, what is the basic meaning and how it's work. Starting with the general introduction, we have we have to discuss about what is international law, that I have already provided to you on this point. Then we will talk about the different organs of United Nations. What is United Nation? United Nation is an it's a body, it's an organization which is actually created long back in the year of 1945. The basic reason for creating United Nations was that the World War II, all the countries, when they, if some of the student belongs to arts, or they have read the history, they must aware that what happened before 1945. So before 1945 there was an organization called League of Nations. The League of Nations has the same responsibility as the United Nations has at present time. They had the responsibility to maintain peace and harmony between these states, to protect the human rights of the people at large. And therefore they created the universal norms that all these states are the part of this world, and when they are creating or they are having the relation with the other state, they must follow certain rules. So League of Nations was the first organization who come up with these objective with them. But unfortunately, as you know that the World War II happened after World War First. The World War II happened, and that was when very unfortunate. That is result of World War II was that there was a loss of humanity and the rights of people So in 1945, five powerful countries come together. They are considered as the founding father of the United Nations, and they stated that we need to create one organization which will protect the human rights of the people, which will protect the relation between the state, and as well as they will maintain the harmony and peace between the state. So for that purpose, they must have certain organs. For example, if you see in the municipal laws, for example, if you take the state of India, in that case, you will see that there we have executive, administrative, and judicial system in India. Similarly, to implement certain laws, there must be some organs. So United Nations comes up with certain organs. So there are basically organs which we are going to there are organ which are actively working at this point, and there are some which are not actively working. We are just talk about, as we have very less time, we will talk only about the important organs of United Nations. That is Security Council, General Assembly, International Court of Justice. These are the three organs which I have shortlisted for discussion today. And we will also discuss about international human rights laws, that why this why this organ was created. This is the first basic object for creation of this organ of United Nations. So we'll also talk about international human rights law, starting with the first organ of United Nations. These are the major organs of United Nations. As I told you that some are working actively and some are not. So we will just skipping the different ones. Still, there are six organs, major organs of UN. I'm just uh, uh, taking the names one by one. That is General Assembly, Security Council, Economic and Social Council, Trusteeship Council, International Court of Justice, and the Secretariat. So these are six basic organs of United Nations. Starting with the General Assembly, first important organ of United Nations is General Assembly. It is considered as the only principal organ of UNO, United Nations organs, which consist all the members. That is why it is also considered as Parliament of Man. So all these states participate in General Assembly. They give their votes and decide the matter if any matters come in front of General Assembly. If you talk about the voting process of General Assembly, then each member state has one vote and five representatives. For example, if India as a state is there in the General Assembly, it will have one vote, and there will be five representatives chosen by the government of India, which will represent India in the General Assembly. If the meeting of General Assembly, if you talk about it, then General Assembly is regularly it's the meeting is fixed, that is in the month of September. In the third week of September, they regularly meet in a year, but it is not compulsory that the meeting will only be held once in a year. It's not compulsory. They can meet, and for that, the special session can be scheduled. This special session can be scheduled by the majority of the members, on the request of majority of members, or on the request of one member representing the other members. If you the next point is that important questions. There are certain important questions which is presented before the General Assembly, and General Assembly has to deal with those important questions by giving the voting to that. which means that with having the voting power, the important questions mean the question related to the peace and security of the world between the states, that is considered as important questions. So when the important questions are presented before the General Assembly, they can deal with that with the help of vote of state. There are certain limitation also. Limitation of General Assembly is that General Assembly cannot deal with the matters which is exclusively dealt by the supposed to dealt by the Security Council. Now, what is Security Council and what is the work of Security Council? Security Council is the other important organ of United Nations. It is considered as the most powerful organ. We will discuss about it in detail, but related to the limitation of General Assembly, the important point to understand here is that the Security Council only deals with the matter of where there is a dispute between the state and the dispute is hampering the international peace and security. So far as the limitation of General Assembly is concerned, General Assembly can the limitation of General Assembly is here is that it cannot deal with the matter which has to be dealt exclusively by Security Council, which means the matter related to the security cannot be dealt by the General Assembly. Another important point to remember here is that General Assembly work as when the Security Council is lacking somewhere. So in that case, it may call attention for the Security Council over a matter of dispute between the state which which will hamper the security of states. So they can call attention for the Security Council over that matter if Security Council is not able to do so till now. So this is about the first organ of United Nations, that is General Assembly. Moving further, second organ of United Nations is important as one of the most important organ of United Nations is Security Council. As I have given you the brief about it, Security Council is it's the originally functioning body, which means it is a separate body from the others organs, and it consists originally it consists 11 members, but since 1965 it consists 15 members. Now, the important point to remember here is that out of 15 members, 5 permanent members are there and 10 are non-permanent. 5 permanent members are China, France, Soviet Union, UK and USA. These permanent member, as the name is suggesting, permanent member, there is no schedule for them. They are permanent. But 10 non-permanent member are elected by the General Assembly for a period of 2 years. So this is again a work of General Assembly to elect the member of Security Council. Coming back to the 5 permanent member of Security Council. These 5 permanent members, including China, France, Soviet Union, UK and USA, are given this powerful position or the privileged position, that is of permanent seat, because these 5 are the founding fathers, considered to be the founding father of United Nations, that I was talking in the initial of the lecture, that when the United Nations was created. So the permanent member are permanent there, but non-permanent member is elected only for 2 years. And the permanent member have certain privileges. That what is the privilege we will discuss later. Let us talk about the retiring process. What is the retiring process? So a member who retired from a non-permanent member who is retired from the General Assembly, from the Security Council, they cannot be re-elected immediately. All right, so they cannot re-elected immediately. So there are certain gap, and then after they can be re-elected. Each member state of Security Council have one representative. So as opposite to the General Assembly, where there are five representatives, Security Council only include one representative. So 15 member, including permanent and non-permanent, and as so the 15 representative from these states. Now, if you talk about the non-permanent member of UN, can they participate uh, in the session of Security Council or in the discussion of the Security Council? In in regard to that, there is the United Nations Charter. United Nations Charter is the law which is being followed for all these things. Okay, so United Nations Charter is the, for example, we have Constitution. So United Nations Charter is considered as the Constitution for United Nations. So member state of UN who is not member of Security Council may participate in the discussion of Security Council if Council consider that the interest of that member are especially affected. So as I told you, the Security Council's work is uh, to see there should be a peace and harmony between these states, and if a non UN member want to participate in the discussion because its interest is affected, it can participate in the discussion with the Security Council, but the exception is that they cannot give their vote. So a non-permanent member, whether of Security Council, cannot give the vote, but they can participate in the discussion. The member state is a party. Second point is that the member state is a party to a dispute. So when a member state was a party to a dispute, they can also participate in Security Council. Um, but without the voting. Moving further, the next important point here is voting process. As we have in India, as we have the voting where we choose our representative. In the Security Council, there is a complicated process where the veto power is provided. Veto power is a privilege provided to the permanent member of Security Council. So basically, as I have discussed with you, that each member state of Security Council has one vote. The decision of Security Council can be on two matters. First is the procedural matter, and second is the substantive matter. Procedural matter is something which is related a matter of less importance, which means that it do not have it do not have importance in the view of the state. For example, the time and place of meeting, adoption of procedural law are some of the example of the procedural matter. Substantive matters are more important because they include the matters which has importance related to the decision of the dispute. Okay, so substantive matters are considered more important if you compare between the procedural matter and substantive matter. So for the substantive, for procedural matter, the affirmative votes of 9 members are important. But in the decision, if the decision has to be taken on the substantive matter, the affirmative vote of 9 member, including concurring votes of 5 permanent member, is important. So that is very important that 5 permanent member voting is important when the matter is has some importance in the nature in the sense of providing the decision. And interesting point here is that the permanent member has a privilege of veto. Veto, what is veto? Veto is a negative vote on the substantive matter, particularly on substantive matter. And once the veto is used by the permanent member, the decision is blocked, or you can say the decision is vetoed, which means that it does not come into the existence. So this is the privilege which is provided to the permanent member of United Nations under Security Council. There is a process of double veto also, which means that when first the permanent member has to decide that matter belongs to which the case which is presented before them belongs to which matter, whether it is procedural one or substantive one. So when they first decide it, then they decide the actual dispute should be given to the favor of which party. So when they first time used the veto to decide the nature of matter, whether it is falling under the procedural or substantive, then they used the veto first time, right? So they decide that matter is a substantive one. Then matter is again presented before the Security Council, and they used, if one of the member of permanent nature use the veto again, then the matter will be dissolved at that time. So this is how, in some cases, the permanent member used double veto. Continuing. Now, some of you and some of those who are preparing for the IAS exam or other competitive exam, they must have this point in mind, that how the veto power is provided to these five permanent members, and why there is no process for changing it. Why we are already we are providing the this privilege to the limited number of states. So there are jurist Kelson who stated that veto power of five members, permanent member, is against the principle of sovereign equality. Sovereign equality means that all these states are sovereign and they're equal. So therefore, these five permanent members, their veto power is against to the sovereign equality which is mentioned under the charter. So this charter gives, the United Nations Charter gives the equality to the states, and the veto power is taking back that equality when the matter is presented before the Security Council. Some of the history of veto is that it was not used by the founding fathers when it was created by them in 1945 till 1993, because after that there was a groupism between these two states. So when if you see the history of these states, when the other states give them the position to become the permanent member of United Nations, they keep it, they had in their mind that these states are powerful, as well as they were united at the time when the world needed them. But afterward, after 1945, it was seen by the other state that they divided into the two groups, that is the Western group and the other. So these five members divided into two groups afterward, and the veto power was not used by them since 1993. Russian federalism used exercise its first time in 11 on 11th May 1993, the veto. So you can see that this is international law, and its process is also considered as the political act of the state. If you relate this point with India, you will get to know that the many state has proposed that India has to, or the member of the permanent nature of Security Council, their number should be increased, and India should be nominated as the permanent member of Security Council, but that is not being done yet. Now, if you talk about the reasons for elimination of veto power, because veto is something which is created for different purposes, but now these states are not, these five permanent states are not using it for that purpose, but for their own advantages. So if you see the reasons for elimination of veto power, first reason and the foremost important reason is that the permanent member of Security Council were great power at the time of creation of United Nations. But if you see their present situation, you will find out that some of these states are not that much powerful. If you, for example, France and Britain are presently not so powerful if you compare it to any other states, for example, Germany and Japan. So therefore, the first and foremost reason is that these states, the permanent members, were considered to be the most powerful, but now they are not. So they must be, this power of veto should be removed. Last important point related to veto power is that once it is used by the any member of Security Council of permanent nature, the matter will be dissolved, and that matter cannot be presented before the Security Council again. Then that matter will shift it to General Assembly. In that General Assembly, all the members are equal, whereby the resolution is passed with a vote by the voting. The decision has to be taken by all members. Let us see some of the functions of Security Council. Functions of Security Council is basically divided into three parts. That is the maintenance of the international peace and security. Secondly, by taking enforcement action, and third is that by measures involving use of armed force. So first important point here is that the Security Council wants to maintain the international peace and security, so they just go for the methods which are peaceful. So for the peaceful resolution of the matter, they adopt certain categories which are considered to be made by these states. First is by negotiation. Article 33, para 1 of the United Nations Charter says that solution by the negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, and by any other peaceful means of their own choice. Whenever there is a dispute between the state and the dispute is presented before the Security Council, they opt the method which is peaceful in nature. So what is peaceful in nature? Just to adopt certain method like negotiation. Negotiating the matter between the two and more states and resolve the matter. Mediation and conciliation is also, and arbitration is also part of the peaceful means. So it provides the justice, it's resolve the matter by peaceful means. If you see the example of Iran and Iraq, so they request these two countries to resolve the matter by peaceful means, by negotiation, and these two states come forward for the negotiation and the dispute was resolved. So this is the first method or first step that Security Council take. Moving further, second is investigation on the dispute. They can also ask the they have power under Article 34. They can investigate the dispute, and after investigation they can resolve the matter, and to they can continue and maintain the international peace and security. Let us see the example. There was a dispute between India and Pakistan that is considered by the Security Council as Indo-Pakistan question in 1948. So in this case, there was need for the investigation. So the Security Council established an independent commission for India and Pakistan to investigate the facts, as there was no clarity related to the facts. So they established an independent commission. After that, the matter was resolved between the two states. Next point is the recommendation of appropriate process. Sometimes what happened that when the matter is presented before the Security Council, it involves the question of law. So when question of law is involved, the matter has to be submitted before the International Court of Justice. International Court of Justice is the court which deal with the international matter and one of the organ of United Nations. Second point, because some says that international law is not true law because it is not true law because it do not have the enforcement mechanism. So these are the examples where the sanctions can be imposed by the security council for maintaining the peace and security. So whenever there is a dispute or situation of serious nature resulting in the threat of peace, breach of peace, or act of aggression, the Security Council has the power to recommend such measures as are necessary to maintain the and restore the peace. So, for restoring the peace and maintenance of the peace, the Security Council can involve the sanctions. What is sanction? Sanction is considered to be a penalty on the state, it or punishment. It can be monetary, that is considered economic sanction. It can be related to the physical sanction, which may include the military sanction. So first, for the cases which, for first of all, the Security Council include the economic sanction. For example, at present, India has blocked everything from every economic privilege that is provided to China earlier. Now it is being blocked. We were using some certain apps of belongs to China. We are not using it anymore because that is banned by Indian government. So these are some of the examples by which the economic blockage can be done to the other state who is not following the or adhere the principle of international law, that is to maintain the peace and security. So economic blockage, cutting of diplomatic relation, military actions, these all can be taken by the United Nations when the state is not following the principles. Examples in the history, you can find the example of Iraq, where the sanction was imposed on Iraq. Libya country is another example where the arm and air embargo, that is a kind of blockage which include the air and military, right? That was also imposed against Libya country. So there are so many example of sanction. Sanction means a sanction, penalty, or punishment. So those who believes that international law is not a true law because it do not involve the enforcement mechanism, that is not totally true. It also have the sanction, which means the punishment, which can be imposed to the state who is against to the principles of United Nations. So here we have covered the second organ of United Nations, that is Security Council. Now, what is the next sanction? Next point is for if you compare it to the India as a state of India, we have third important pillar is judiciary. Similarly, here also we have under international law, the third important pillar is International Court of Justice. That is considered, in short, we can call it ICJ. So ICJ is so ICJ is considered to be the permanent court for to resolve the international dispute, and it was adopted in the need for adoption of the establishment of permanent court was felt in the Hague Conference, and before the International Court of Justice, there was Permanent Court of International Justice, which was there for some period of time. It works for the League of Nations. As I remember that, if you remember that League of Nations is the previous organ which work for the peace and for security of the nations. And after the dissolution of that, the International Court of Justice start functioning from 18th April 1946. So ICJ is again considered as the principal organ of UNO, and all the members, those who are the member of UN, is ipso facto or by in itself automatically become the parties to the statute of International Court of Justice. If any matter is between those states, the matter will be dealt by the International Court of Justice, and all the members are under the obligation to follow and comply the decision of the court. If you talk about the judges, the International Court of Justice include 15 judges, which are basically elected regardless of their nationality, which means that person, the judicial person who has the knowledge of that and has the high moral character, possesses the qualification to require to be the higher judicial officer of their own state, can be considered a judge of International Court of Justice. But important point here is that not two judges shall be elected from the same state, which means that 15 judges from the 15 different states. Election process. What is the how judges are elected? So 1/3, that is the 5 members, are elected once in every 3 years. Thus, once it is elected, the judge enjoy for a period of 9 years, and they are eligible for re-election. Okay, so these are the election process of International Court of Justice. Jurisdiction. Jurisdiction is the power to deal with the matter. The meaning of jurisdiction is the power of deal with the matter of court. Power of court to deal with the matters. So basically, ICJ enjoy two types of jurisdiction. First is compulsory and obligatory, and second is optional one. Under optional clause, they under the first we will talk about the compulsory and obligatory jurisdiction. Compulsory and obligatory jurisdiction means that the court will have the disputes. It will hear the disputes which is between the members of United Nations. So it is obligatory on them, and it is compulsory to have the jurisdiction of the International Court of Justice. Second is advisory jurisdiction. Advisory jurisdiction means that sometimes in the front of or before the other organs of United Nations, there is a matter can be fall before them which involve the legal issue. Okay, so in that case, the General Assembly or the Security Council may request the International Court of Justice to give advices, to give advisory opinion on and legal questions. So when there is a legal question is involved, the Security Council and General Assembly may ask the International Court of Justice to provide its opinion, legal opinion. That is falling under the advisory jurisdiction. So, except these two, General Assembly and Security Council, other organs or specialized agencies of United Nations, they also have the rights to ask the legal question from the International Court of Justice if they have any question. So this is how the United Nations works, it has the different organs, it has different agencies and organization which is constituted for the different purposes. Now, completing with these two important point, the third point is international human rights laws. International human rights is considered to be one of the major object for constituting the United Nations. So before discussing international human rights laws, we need to discuss what is human rights. Human rights are those rights which are provided to the human, to provide it to all humans for by virtue of being it, which means that by birth the humans got these rights. So but these rights are not completed when they take birth as a human. These right has to be protected. These right has to be protected from the society, protected from the different aspects. So human rights define the minimum standards and rules of procedure which must be availed to people in general by a state authority. For example, by the government, by police, by armed force, by also such institute as an international organization, business units and other that expert power on people. So these human rights are the minimum standards and rules which has to be protected and by the states from the different people from different aspects. So to secure the rights, to secure such rights, the international human rights was evolved. If we talk about the evolution of human rights, the it was evolved before long back in 1200th century by the King John. He introduced the Magna Carta, and afterward by the American Resolution and by the French Resolution, slowly and gradually international human rights were developed. And interestingly, when the human rights were adopted by the United Nations, because the founding nations, they understand that there was a horror of the World War II, and they emphasize at the first time that the similar rights of man should be implemented for each state to adhere it. That means that they will come up with the some minimum standard of human rights that has to be implemented by the states in their own local laws or domestic laws. So this is how the international law work, and any part of international law work that they come up with these certain standards that has to be followed by the other states if they become a part, if they are part of it, or if they sign the treaty or agreement. So there are certain conventions on human rights which provide the minimum standards. So before coming to that point, we need to discuss what is what are the certain examples of human rights that has to be protected by the states in their domestic laws. So let me give you simplifying this. I give you one example. Under Indian Constitution, we have right to education. If some of you are aware about it, is right to education, Article 21A. Similarly, we have the legislation, that is the Right to Education Act 2005. So this is how the state is protecting the rights, human rights of the people. So fundamental right which is mentioned under the constitution, Indian constitution, is the resemblance, it has the resemble, or it is considered to be the mirror image of certain documents of international law. So we adopted those laws and implemented in India. Let us see some rights, what right I'm talking about. For example, the security rights to prohibit crimes. Liberty right, you have right to you have right and liberty. Freedom in areas such as belief, religion, association, assembly, and movement. These are the rights which is related to the liberty. Political right. Political right is one of the important right under human rights. So people ignore it, but it is the right which you have to choose to participate in politics, to express themselves, protecting and participating in a republic. So this is again the important right which has to be protected. In India, you will see that people do not give vote. They actually, if they elected, also they are not coming in front of people. That they are represented by their husbands. Some in some areas, women represent those who are elected as a as the those who are chosen by the people. They do not they never come in front of people, but they are represented by their husbands. So these kinds of rights is provided under the international law, that it should be protected. Next, due process right, to protect against abuses of legal system, such as when imprisonment without trial, secret trial, or excessive punishment. So, for every offense in law, there is a particular punishment, and there is a process that has to be followed by the police or by other administrative officers. If someone arrested, there are certain process. So that procedural law, that the arrested person has right to present before themselves in front of magistrate. They have right to call their relative and inform them that they have been arrested. So these right is provided under international law as well as under municipal laws, under the constitution as and the legislations. Next is the welfare right or economic right. Economic right include the right to education, to provide holidays, protection against the poverty and starvation. These are the welfare and economic rights. And the last right, not least, is group rights. Group rights means that right which is not actually used or enjoyed by one individual, but by all of us collectively. That is considered as group right. For example, the to provide protection to a particular group, okay, against an genocide, or from the ownership by the countries of their nation, territories, and resources. So, a particular group, vulnerable group, disabled people, women, LGBT are all coming under these rights. So, the group rights are provided to not an individual but in collectively to a group. So, these are the basic introduction to human rights. Let us understand how human rights were developed. The charter which I'm talking about, that is the constitution considered to be the constitution of United Nations, was firstly evolved in 1945. Then the first declaration is that we as a member of United Nations adhere here that we will protect the human rights. First declaration was come in 1948, that is considered to be the Universal Declaration of Human Rights. Universal Declaration of Human Rights included all the rights of human, which was developed for in a period of long time, starting from the first Magna Carta and then to 1945. It included 30 articles, and if you understand that at that time when we got independence, we also come up with the constitution in and in part third of constitution under fundamental rights. 22 articles are inspired from the Universal Declaration of Human Rights. That means that 22 human rights we have inspired as a state, we have inspired from the Universal Declaration of Human Rights. We adhere the human rights which are mentioned under these declaration. So declaration is nothing, it's just a declaration, it's a declaring by a state that we as an individual state, I as an individual state will implement these international minimum standard of human right to the local legislation or to the domestic laws. After 1945, when the Universal Declaration came into existence, it was felt by the United Nations that some state has implemented that voluntarily, and some state did not implement that. So what they have done, they come up with two more conventions. Conventions is a kind of agreement. When there is an agreement, the people, as you know, that when there is an agreement, you have to bound by the provision of agreement. Similarly, here in the convention, if the states sign, they are bound to follow. If they ratify it, they are bound to follow the same international standard to their municipal laws. So therefore, the United Nations got to know that as it is a declaration, it is a kind of morality, and states are not implementing it. So they come up with they come up with two more conventions that is considered to be the very important convention of human rights in the area of human rights, that is International Convention of Civil and Political Right 1966 and International Convention of Economic, Social and Cultural Rights 1966. Same in the same years these two rights were implemented, where civil and political rights provides you the liberty, right to life, the right to participate in the politics, and it is, you will find out that it is mentioned under the fundamental rights of constitution. International Convention of Economic, Social and Cultural Right provides you the economic right, that is, some example of economic right is right to education, right to equal pay for equal work. Social and cultural right, cultural rights means that as an India, we have different states, diversity, so we have different culture also, and we celebrate that culture, right? We have our own way to celebrate the different events of life. So these two conventions actually considered to be the children of UDHR. In a layman language, I would say that it is UDHR is a parent and these two are the kids. But these kids are bound. The kids are the state, if they have ratified, they are bound to follow the minimum standards of human rights in their municipal laws. And this is how these four conventions and declaration considered to be the international bill of human rights. Okay, so this is how I will conclude my lecture here, because it's we are running out of time here. So in conclusion, I would say that international law is something which cannot be dealt in a particular time, or it takes it a proper subject, and it cannot be dealt in one hour time, short period of time. Still, I have tried to explain you the major parts of United Nations, how what was the objective of it, and the organs of it, and the international human rights law. Thank you.
That was very interesting session, sir. We got to know a lot about international law, not just even international law, laws which are within our country, and laws which are covered throughout the world. So yes, we have few questions in the chat. One is, sir, what if the law of two countries are against each other? Sujal Sujitra is asking this question to you.
Can you please come again?
Okay. The question is, what if the laws of two countries are against each other?
The laws of two countries are against each other. Okay, so the that is falling under the private international law. Actually, if the laws are against to each other, there is standards of laws, and that is the falling under the international law. We have already set of rules that has to be governed.
Okay, sir. Sir, I would like to ask you a question. It would be a great help if you suggest some books or some tips to the students who are preparing for competitive exams for preparing international law.
Yes. So for the students who are preparing for competitive exams, the books for international law can be the Dr. S.K. Kapoor, Dr. H.O. Agrawal. These are the best author for international law, and I think that would be sufficient enough for them. They have to read the newspaper and journal knowledge is also they it may help them to crack the exam.
Great, sir. Uh, any questions? The viewers can type the questions in the chat box if anyone is having any question. Sir, would you like to give a message to the students who are preparing for competitive exam? Any general message for the motivation?
Okay, I would say that you should continue with your practice, and you should study with your all the material with whatever you have, and you should now at present we have the online classes, so you can have the proper material, and specifically for international law, the general knowledge that what is happening around in the world is very important. So you can read certain books, and you can go to the websites also of newspapers, and you can have the knowledge of international law. For competitive exam, I would say that it will take some time, but yes, one day you will get the result of your hard work. So don't feel negative. Just be focused on your study, and you will be successful one day.
With that beautiful message, we would like to give you a vote of thanks, sir, on behalf of Genius Group of Institutions, our chairman, sir, our CEO, Genius Lakshya founder Rohit Shikha, sir, and entire staff and students are thanking you with a warm heart that you gave your time to us. Your valuable words means a lot to all of us. Thank you, sir, for being with us today, for guiding our students with such a beautiful topic and such a informative topic. Thank you, sir. We would like to end our session today here. Sir, anything
Thank you
from
so
your
much for
part?
calling. Thank you so much
We
for calling me.
we are glad to have you, sir. Thank you. So that's all for today's Genius Lakshya. Let's wave a goodbye to our today's expert, Rupaksh Sharma, sir. Thank you, sir. Goodbye to you.